If you die without a will, your money still goes somewhere. Most people assume it just goes to their family, and it sort of does, but not the way you'd think, and not always to the people you'd actually choose. You see, when you don't write a will, the state has basically already written one for you. There's a formula sitting on the books in your state that decides exactly who gets what, in what order, and it does not know a single thing about you. It doesn't know who you love, who you'd cut out, or who you'd want taken care of. It just runs the math. My name is Omeed Tabiei, and I'm an estate planning attorney here in California, and I've helped dozens of families either avoid this mess or clean it up after the fact. In this video, I'll show you exactly who gets your money when you die without a will, because once you see the formula, you'll want to get ahead of it. The state already wrote a will for you. Let's start with the word, because you're going to hear it if this ever happens to your family. Dying without a will has a legal name, and it's called dying intestate. And dying intestate does not mean your family sits down and figures it out. It doesn't mean your spouse automatically gets everything. It means the state steps in and applies its own set of rules. Every state has what's called an intestate succession law. It's a fixed order of who inherits, and it runs the same way every time. Your wishes, your relationships, none of that gets a vote. So the real question isn't whether your money gets distributed. It does. The question is whether you want the state deciding that, or you. Who actually gets your money? Okay, so here's the formula itself. The actual order most states follow. If you're married, your money generally goes to your spouse. But if you're married with kids, it usually gets split between your spouse and your children. It's not always all to the spouse like people assume. Now, here in California, there's a wrinkle to that, and it actually matters a lot. California is what's called a community property state. That means anything you and your spouse earned or acquired during your marriage, generally speaking, belongs to both of you equally. So when you die without a will, your spouse automatically keeps 100% of that community property is what it's called. No splitting with the kids at all. It's only your separate property, the stuff you owned before the marriage, or inherited, or was gifted specifically to you, that gets divided between your spouse and your children. And how it's divided depends on how many kids you have. One child, your spouse gets half of the separate property. 2 or more kids, your spouse gets a third. So if most of what you own was built during the marriage, your spouse is probably fine. But if you've got separate property in the mix, maybe an inheritance, maybe a business you started before you got married, that's the part the formula starts dividing up, and that's where families get surprised. If you're single with no kids, it moves up to your parents. If your parents are already gone, it moves out to your brothers and sisters. And if a brother or sister already passed, but they had kids, that share drops down to their kids, so your nieces and nephews. It keeps working outward like that, further and further down the family tree. And the surprising thing is, if they can't find any living relatives at all, your entire estate goes to the state government. Everything you built, gone to the state, forever. So the money doesn't vanish, it just follows a rigid line, and you have zero say in where it stops. Some of your money skips the formula. Now, before you panic, there's something important you need to know, because not everything you own runs through this formula. Some of your assets pass directly to a person no matter what, will or no will. Anything with a named beneficiary skips the line. Life insurance goes straight to whoever you named. Retirement accounts, your 401k, your IRA, goes straight to your named beneficiary. Anything you own jointly with rights of survivorship goes to the other owner automatically. So a house you own with your spouse, that just becomes theirs. And bank accounts with a transfer on death or pay on death setup goes straight to the person you named. No court involved. So here's your action item for today. Pause this and go check your accounts. If your account has a beneficiary named, good. that person gets it directly. If it has no beneficiary, that money falls right back into the state's formula and goes through probate. The two traps the formula creates. Now, the formula doesn't just decide who gets your money, it can actively work against the people you care about most. The first trap it creates is if you have an unmarried partner. You could be with someone for 15 years, share a home, share a life. And if you're not married and you don't have a will, they can legally get nothing. Not because anyone's being cruel, the formula just doesn't recognize them. The only exception is common law marriage, which only a very few handful of states recognize, places like Texas and Colorado. California, where I am, definitely does not recognize common law marriages. So if you're watching this in California, the common law marriage exception doesn't apply to you at all. California abolished common law marriage back in 1895. Doesn't matter if you've been together 20 years, own a house together, raised kids together. If you never made it legal, the state does not consider you married, period. So if you're in a long-term relationship here in California and you're not married, a will isn't optional for you. It's the only thing that gets your partner anything. The second trap is about the relatives you wouldn't choose, because the formula follows blood, not closeness. And I've seen situations where someone has a sibling they haven't spoken to in years, and that sibling can legally walk in and claim a piece of your estate. So the people you'd want to protect can get cut out, and the people you'd never pick can get a check, all because you let the formula decide. Now, real quick, if you're sitting here realizing the state's formula isn't what you'd actually choose, that's exactly the thing I help families fix. There's a link in the description below to book a free consultation with me. We'll look at your situation and figure out what you actually need. All right, let's get back to the video. It's not just your money, it's your kids. It's important to understand that the formula doesn't only handle your assets. If you have young kids and you die without a will, a judge decides who raises them. A judge you've never met. Someone who doesn't know your family, doesn't know who you trust, doesn't know the person you always assumed would step in. The court follows legal criteria, not your relationships. And if more than one family member wants guardianship, your kids can end up in the middle of a custody fight at the worst possible moment of their lives. A will is the one place you get to name the exact person you want raising your children. For a lot of parents, that single thing is the whole reason they finally sit down and do this. Digital assets. Your digital life doesn't pass through that formula. It can just vanish, and a lot of money can disappear here. Cryptocurrency sitting in a private wallet with no documented access when you die, that's gone. No court can recover it. Same goes for online businesses, domain names, a PayPal balance, any income from monetized accounts. Without documented instructions, your family may never be able to get to any of it. But a will can include a digital assets clause. It names who's in charge of it and documents where your access lives so it doesn't die or just vanish with you. What this can cost your family. So let's talk about what this whole process actually costs your family, because it's not free and it's not fast. All of this runs through probate, the court-supervised process of distributing what you owned. Without a will, that typically takes anywhere from 9 to 2 years. And during that time, accounts can sit frozen while your family still has to cover the mortgage, the bills, all of it. It also costs money in legal fees. That's usually about 3 to 8% of your estate's value, and that's all public. Probate is public record, so anyone can look up what you owned and who got it. So the formula doesn't just decide who gets your money, it slows everything down, drains a chunk of it, and puts your business out in the open. Here's how you take control back. There's good news, because every single thing I just described is avoidable. The will takes the pen out of the state's hand and puts it in yours. You decide who gets what instead of the formula. You name the person who manages it all, and if you've got kids, you name their guardian. And if you want to go a step further, a living trust skips the probate process altogether. Your assets pass directly to the people you choose, no court, no public record, no waiting. The point is simple. You can either let a formula you've never read decide all of this, or you can decide it yourself in an afternoon with me. So if you want to make sure your money, your home, and your kids end up exactly where you want them to, click the link below in the description and book a free consultation with me. We'll figure out what actually fits your situation and get it handled so your family never has to deal with any of this. Again, you can book your free consultation using the link below. And if you're now wondering whether you actually need a trust or if a will is enough, then watch this video next.